What I want to talk to you about today is a bit of a hot topic, really, at least it certainly is so far as the criminal law is concerned. That is bribery and corruption. But I'm not going to talk about it from the criminal perspective, although our Minister of Justice, or is he Lord Chancellor, I'm never too sure, Mr. Jack Straw, stated bribery eats away at the heart of both business and public life and has no place in British commerce. It blights free and fair competition and adds to the cost of doing business. It's particularly harmful to trade and development in the fragile economies of the developing world. When he introduced the Bribery Bill to the House of Commons, now of course the Bribery Act 2010, which parts of it came into force on April the 8th this very month, and parts are due to come into force on such date as the Secretary of State may put forward the appropriate orders. The modern civil law relating to bribery and corruption provides claimants with pretty effective and indeed quite fearsome remedies. Now, of course, there's been lots of debate in the papers with international companies apparently getting awfully worried about what is going to constitute bribery for the purposes of the Bribery Act 2010, the replacement, of course, of the Prevention of Corruption Act of 1906 and indeed the Public Bodies Corruption Act of 1889. But none of that is for my purposes. That's not what we're going to deal with in this seminar, although their fear that giving someone a seat in debenture at Wimbledon may be a little overplaced would be my take on it. We're going to start with a look at two cases towards the end of the 19th century. I could go back a lot further, but this seems an appropriate point. The first of them is the well-known case of Boston Deep Sea Fishing and Ice Company versus Ansell. In this case, the case went to a Court of Appeal composed of, amongst others, Lord Justice Bowen and Lord Justice Fry, on an appeal from a decision of that well-known Chancery Judge, Mr. Justice Kekovich. And in the Court of Appeal, they reversed Mr. Justice Kekovich's decision. They concluded that the secret receipt of a commission by the managing director of a company for the placing of orders to build ships was a breach of his duty to the company and was a profit which belonged to the company and not to the managing director. That's what Lord Justice Bowen said, and Lord Justice Fry said it was a fraud, according to the simple dictates of conscience, giving a right of recovery. 2 years later, we had a case of Lister and Stubbs, where in that case the Court of Appeal refused an application by the employer to pursue commissions that had been received illegally into the investments in which those monies had been placed, on the grounds that fraud did not give rise to any constructive trust or proprietary remedy. They, in 1890, relied on two principal grounds. The first was that if the fiduciary was in equity a debtor of the person injured, then he couldn't also be a trustee for the bribe. And secondly, if the fiduciary, that's the agent or the employee, becomes insolvent, then his unsecured creditors would be deprived of any right to share in the proceeds of the relevant property. So, you can recover the money, but you can't follow it into the investments in which it's been placed. That was the position at the end of the 19th century. In a case at the very beginning of the 20th century, Hovenden and Sons and Milhoff, three principles were well and truly established. First, once a bribe has been proved, there's an irrebuttable presumption that it was given with the intention of inducing the agent to act favourably to the payer, and thereafter unfavourably to the agent's principal. Secondly, the motive of the donor, the payer that is, in making the payment to the agent is conclusively presumed against him, and it's conclusively presumed against him that by making the payment, the agent, the recipient of the bribe, is affected and influenced by the payment. And thirdly, that it must be presumed that the price, for example, of goods is loaded as against the principal, at least by the amount of the bribe.